Hi, Ed Terzian here, founding attorney of the Inheritance Recovery Attorneys. We specialize in representing individuals with respect to their beneficial interests in their loved ones' estates. We're often looking at invalidation, contesting of trusts, contesting of estate plans. Last video, I spoke a bit about what areas we focus on typically when we're looking to see if there's grounds to invalidate, contest a trust. And I'd say generally the area we focus on most and find that most of our cases fall under are undue influence. Spoke a bit about lack of testamentary capacity. Today I want to actually talk about something else that is simply protection of what the estate terms are, meaning we're not contesting it. But you've got a trustee or somebody who's in control of all of the assets and who simply is not refuses to carry out their duties under the trust. So typical example would be, you've got brother, let's call it, and brother is appointed as the sole successor trustee under the trust. And, typically in a case, where we're getting siblings coming to us and saying, trustee's not doing their job, there's already a history there. There's a lack of trust, and what we see often where a trustee is abusing their discretion, abusing their, positions of authority, it comes from their lack of communication and their refusal to provide information that's reasonably necessary for the beneficiaries to understand their rights. Sometimes it starts right from the get-go where, let's take mom passes away, successor trustee is not providing a copy of the trust to any of the nearest living heirs. Even if the nearest living heirs are not in the trust, let's say it's just one individual, the trustee has a duty to provide a full copy to all of the nearest living heirs, regardless of whether they're actually named as beneficiaries. The trustee's supposed to send out a notification. It's called a trustee's notification, and basically it says, mom, passed away on this date, and I'm the successor trustee, and the trust is being administered here, wherever they are, and often with that they do send a copy of the trust. If not, the notification is supposed to give everybody the right to request a full copy of it. Again, even if you're not in the trust, if you're a nearest living heir, you have a right to the terms of that trust to determine whether you in fact want to contest it. But as I said, in this case, want to briefly talk about what it looks like when you get the copy of the trust finally, and you're in it, but somehow the trustee is simply not carrying out their duties. Either they live in the property and they have no incentive, no motive, no desire to sell the property and distribute it to all the beneficiaries, or they are taking their time and not with a good, reasonable excuse and explanation for the delay. Often what I'm seeing in these cases is there's some sort of motive that the trustee has where they're delaying the distribution. And, a typical example, one I'm dealing with right now is brother, was very upset with sister for various reasons from their childhood forward. Now he's in, a position of strength, I suppose, as the trustee. All of the resources are with him. And he believes that he should be able to force our client to take a discount, to be punished for her past. And so he's well aware that she, needs this money to pay bills. And he's well aware that she's almost in a sense at the whim of this, unfortunately, of this money that's to be coming to her. And he's taking his time. We've had to file a lawsuit, of course. This is not a unique situation. It happens all the time. We have several of them. I'm just thinking of this particular case. We are in the middle of a lawsuit that's been pending for months now. And sadly, he's forced her into litigation. We advance costs and fees. Our fees come out of the back end, and often the reason that the trustee does this is because they are hopeful and reliant and believe that no way any of the beneficiaries or the beneficiary can afford an attorney. So it's part of their strategy to force them into litigation. We find, of course, that it does help when we take our fees out of the recovery rather than, on a monthly basis, and that certainly helps. The problem, however, is, regardless, we have to put in the work. The trustee's attorney has to put in work. And now everybody's running up fees simply in order to get the trustee to do their job. At the end of the day, attorney's fees can be recovered if the wrong is proven to be malicious and shown to be the fault of the trustee. But it takes time, and it's an effort, and it's a frustrating one, I'll be honest. Often, the beneficiaries, the ones that don't have the assets, are in this natural position of fighting, having to fight upwards in order to force the trustee to be reasonable. And often the trustee will find an attorney who tends to hide behind procedure and delay and make it very difficult while they bill hourly and they bill the trust. And so it's this element that exists with many cases. And you often, again, see it with trustees that have this sense of desire to control information, control everybody's interest, to just make it difficult for everybody. And luckily, there are tools that we have, to fight that in court. And certainly clients in that position are in a better position than if they had been written out. And so their lawsuit is more looking like, rather than contesting the estate plan, it's a petition to enforce the estate plan, to compel the trustee to fulfill their duties under the trust, and for removal often of the trustee if they've breached their duties, and for an accounting, etc. So anyways, that's a bit of an overview with a different sort of case and situation that we handle. And hopefully you've got something out of that, and reach out to us. Love to see if we can help you. Thank you.